Hello, this video will take a look at criminal law and business. As you recall from some of the earlier chapters, an individual or business can file a civil lawsuit. In criminal law, the government is the one bringing the action on behalf of the people. Also, remember that in civil court, the burden of proof is preponderance of the evidence, more likely than not that the facts occurred one way versus the other. In criminal court, the burden is higher, beyond a reasonable doubt. So now let's take a look at what the elements are for crimes. In order to prove criminal liability, two elements of crime must be established. The first element is an actus reus, which represents wrongful behavior or a guilty act. The second element is mens rea, which demonstrates a wrongful or guilty state of mind, such as purposefully, knowingly, recklessly, negligently. To prove the first element, the government has to show that the prohibited act or consequence occurred because of the defendant's behavior. In order to prove the second element, the government has to show that the defendant acted with the state of mind defined in the law. This is where you see the words purposefully, knowingly, etc. in the statutes. If you have a moment, please watch this video. It takes a look at actus reus and mens rea, but also is building a case for why we should always have mens rea in our criminal statutes. There are some statutes that don't require it, so that's what this video talks about.
This is mens rea in 60 seconds. That mean judge in Legally Blonde didn't need mens rea explained, but you might. Every crime has two parts, the bad action, or actus reus, and the bad intent, which is mens rea. Proving someone guilty means proving action and intention. And there are different levels of intent. Did he intend to commit a crime? Was he reckless, or was he negligent? These levels of intent are older than the United States itself. But now, laws are being written without a mens rea requirement, meaning a person can be guilty even if she never meant to break the law, or had no idea she was doing something illegal. People have faced large fines and even prison time for things like mislabeling orchids and releasing balloons into the air. One man even got more than 6 years because he didn't know shipping lobsters in plastic bags was a crime. Sorry, I didn't know. Shouldn't become a defense. But we need to consider intent to make sure innocent people don't face prison time. Future laws should take intent into account, and we should use a default level of intent for old laws that don't have a mens rea requirement.
All right, so let's take a look at just a law that I found that's related to crime. And just so that you can see what it looks like in real life when you look at a statute. So when we were talking about mens rea and the, knowingly, willfully, etc., that is usually written in the law, that's where you find it. So you can look up any law, and when you look it up, any criminal law, I should say, any criminal statute, you should be able to find these words: knowingly, fraudulently, willfully. This is the state of mind needed to commit these crimes. Crimes can be classified as felonies, misdemeanors, or things considered petty offenses. So felonies are serious crimes punishable by imprisonment for greater than 1 year or death penalty where applicable. Misdemeanors are less serious crimes punishable by fines or imprisonment for less than 1 year. And petty offenses are minor misdemeanors, usually punishable by small fines or short jail sentences. White-collar crime is generally defined as a variety of nonviolent illegal acts against society that occur most frequently in the business context. And so we're going to talk specifically about 5 or so of those crimes. And so white-collar crimes typically involve things like bribery, extortion, fraud, embezzlement. They're nonviolent offenses that have cheating as kind of the central element of the crime. Bribery is generally defined as the offering, giving, soliciting, or receiving of money or any object of value for the purpose of influencing the judgment or conduct of a person in a position of trust. One of the most recent cases of bribery that many of you may be aware is the college bribery scheme with Lori Lori Loughlin, and several other folks that were, paying for their kids to basically get into college. And you can click that link if you want to learn more about that story if you've never heard of it. Extortion, otherwise known as blackmail, we talked a little bit about in contracts, but represents the making of threats for the purpose of obtaining money or property. So I'm going to tell you a story about Ted and Marie Roberts. Ted and Marie Roberts were a San Antonio couple who had 3 kids, and both of them were attorneys. They were not likely candidates to mastermind an elaborate blackmail scheme, but the seeds were planted, I think, in about 2001 when Mary had an affair with several different men, I think 5 different men. Ted, her husband, became suspicious and hired a private investigator to uncover this evidence of his wife's infidelity. So while Ted was really angry initially, he ultimately decided to use this situation to his advantage. And Ted told one of his investigators that he was planning to confront all of Mary's lovers, saying they'd better bring a checkbook because if they're going to be writing a check to my favorite charity, me. All of these men were married and had prominent careers, so they had a lot to lose if their secret affairs were revealed with Mary. So Ted used his legal knowledge to exploit an obscure Texas provision rule. I think it's like something like Rule 202, which allows an attorney to file a deposition for any civil suit. Even if the suit has no merit, the details of the case would still become public record. So a prospect which terrified Mary's lovers, Ted did not actually file any depositions, but he typed up some fake petitions to investigate potential claims, documents containing all of the sordid details of Mary's affair. When Mary presented these documents to her former lover, Ted shook them down for money in exchange for not filing the alleged petitions. And the couple in this scheme together, both attorneys who are held to ethical standards, managed to extort, I think, $155,000. But this scheme ended when Ted's law partner uncovered copies of the fake petitions and turned them over to authorities. The couple was charged with blackmail and extortion, and Ted received 5 years in prison, and Mary received 10 years of probation. So just a really interesting story about blackmail. So fraud consists of a variety of means by which an individual intentionally uses some sort of misrepresentation to gain advantage over another person. So I'm going to tell you the example of Theranos, Elizabeth Holmes, who was one of the founder of Theranos, which was a health technology company. So Elizabeth promised to change the world of medicine with this new technology. And she lured investors like Henry Kissinger and James Mathis in a partnership with Walgreens. And Holmes performed demonstrations using other companies' technology while claiming it was the work of Theranos. And the SEC charged Holmes with lying to create more than $700 million for Theranos in outside investments. And Holmes reached a settlement and agreed to pay $500,000 in a fine, and handed over 19 million shares of the company, and is not allowed to be an officer of a public company for 10 years. So a really recent example of fraud and kind of a bizarre case. Fraud generally requires proof of the following elements, and we've seen fraud when we talked about contracts, when we talked about fraudulent misrepresentation, but this is a little bit different because it falls under criminal law. And criminal statutes have sometimes slightly different requirements. So one, we have to have a material false representation made with an intent to deceive. Again, there's that mens rea piece. We have to have that mindset. And the victim's responsible reliance on false representation, so similar to contracts, and damages. All right, so in your book, I think it's Exhibit 6.1 or 6-1 of the textbook, it illustrates certain types of fraud-based claims. So fraud-based claims involve fraud as an essential element of the crime. Crimes involving fraud includes things like forgery, false entries, false token, false pretenses, fraudulent concealment, mail fraud, healthcare fraud, telemarketing fraud, Ponzi schemes, pretexting, and like insurance fraud that we talked about earlier in the year. All right, so now let's talk about embezzlement. And embezzlement we hear about a lot in the news. Embezzlement is defined as the wrongful conversion of another's property by one who is lawfully in possession of that property. So that's why it generally involves folks who are employees. If you get a moment, take a look at this link. This is a link to one of the largest embezzlement scandals in Wake history. It involves someone named Hugh Johnson. Hugh worked for a company called BMG in Cary. It was a German firm that made instruments in pharmaceutical biotechnology industries and ran data analytics and that type of thing. But he was charging major dollars on company dime, trips to Cancun, $25,000 birthday celebrations, lavish dinner parties to Ruth Chris, subscription to wine clubs, and he even had some pornography on the BMG credit cards. And so he ended up receiving consecutive sentences of 70 to 96 months in prison. And so one of the larger embezzlement cases in the county. So let's look at computer crimes, probably an emerging issue. That computer crimes are generally defined as any wrongful act that is directed against computers, using computers commit a crime, or involving computers. And this is one that can be layered upon other crimes as well. So now I want to switch gears a little bit and talk about criminal procedure. A lot of this is going to look familiar just because we've already talked about civil procedure. So remember, criminal procedure differs from civil procedure in several ways. First, the government, through a prosecutor, always brings a criminal case, while a civil case, the parties file the case. The plaintiff can be an individual, business, or government entity. Second, in a criminal case, the object is punishment in the form of criminal fines or imprisonment. While in a civil case, the objective is to remedy the wrong done to the plaintiff. So the defendant will either have to pay money damages or be subject to some sort of equitable remedy in the form of an injunction or other specific order of performance. Finally, because the potential impact of losing a criminal case is so much more serious than the impact of losing a civil case, the Constitution provides a number of safeguards for criminal defendants. The first one is the Fourth Amendment of the United States Constitution, which prohibits unreasonable search and seizures. It generally requires a warrant before search or seizure can occur and restricts the issuance of warrants by requiring probable cause. Now, I'm going to make this very simplistic. I would say if you want to learn more about criminal procedure and applicability of the Constitution, I would maybe take a criminal law class. The next constitutional safeguard is the Fifth Amendment, and it does three things. You know, we hear, some of you have seen that Dave Chappelle clip where he's like, I plead the fifth. And the fifth element is a little bit more broader than just the right to not incriminate oneself. That's the one that's used primarily on TV. But the Fifth Amendment also includes a prohibition against double jeopardy, so being charged for the same crime twice, and then the general right to due process, again, because we are dealing with a person's rights. The Sixth Amendment has a variety of safeguards. One, the right to a speedy and public trial, the right to trial by an impartial jury of one's peers. Again, something that we've talked about in earlier sessions about what that really looks like, and is that constitutional safeguard really being met? Right to be informed of the accusations against oneself, and right to confrontation of witnesses, right to have witnesses on one side, right to counsel at various stages of proceedings. The Eighth Amendment includes safeguards for freedom from excessive bail, freedoms from excessive fines, freedom from cruel and unusual punishment. Again, something that's tested in a variety of different ways, but I just want you to have a general gist of what these amendments do for criminal procedure. And then the 14th Amendment is the extension of the right to due process to all state matters, extension of the most constitutional rights to defendants at any state level. And remember, with civil trials, we have a process. The pretrial procedure for criminal behavior or criminal procedure is a little bit different. One, we usually start out with an arrest, and then that person is booked, and then they have a first appearance, and then there's an indictment, and then there's an arraignment. And so these are kind of the steps that we get before we get to our trial stages for criminal law. One, just kind of be familiar with the Miranda rights. So before a law enforcement officer engages in some sort of what we would call custodial interrogation, they must inform the defendant of the following rights. And we've heard these before. You have the right to remain silent and to refuse to answer any questions. Anything you say can and will be used against you in a court of law. You have the right to an attorney, a right to consult an attorney before speaking to the police, and you have the right to present any questions during that time or in the future. If you can't afford an attorney, one will be appointed before the questioning begins. If you don't have an attorney available, you have the right to remain silent until you have the opportunity to consult one. And now that I've advised you of these rights, are you willing to answer any questions without an attorney present? And that set of Miranda rights has been challenged in the courts time and time again. Based on the little nuances that are in it. So tons of opportunity to learn more about those areas, but I just wanted you to have a kind of a quick snapshot of those rights. So when we get to our trial procedure, we do our jury selection, and then we have a trial. Now, the burden of proof is on the prosecutor. It is not the burden of the proof of the defense. The defense just merely has to poke holes in the proof presented by the prosecution. So that's a complete strategy that's different in criminal procedure. Then there's jury deliberations, the jury verdict, and then there's a sentencing hearing if the defendant is found guilty. There are some affirmative defenses to crimes that say, hey, yeah, this took place, but here's my defense. One is infancy. A person who's not yet a legal adult may use this defense to diffuse the guilty mind component requirement of a crime. Again, not a full win, but an effort. Mistake of fact. The defense says their honest and reasonable mistake about the facts relevant to the commission of the crime negates the idea of the guilty mind. Again, this is where we're going after the guilty mind element. Intoxication, we talked about that in contract law, where the defendant says that they took an intoxicant without awareness of its likely effect, mistook its identity, or took the intoxicant under force. Remember, with intoxication, intentional intoxication is not a defense, but involuntary intoxication, or in this place, more like negligent behavior that leads to intoxication, may be a defense. Insanity, perhaps the defense most of us are familiar with. The defendant contends that they had severe mental illness that substantially impaired the defendant's capacity to understand and appreciate the moral wrongfulness of the act. Again, another area in criminal law that's been dealt with in a variety of different ways. Duress, similar to what we saw in contract law, the defendant says that they were forced to perform an act against their will. Entrapment, the defendant contends that they would not have committed the crime or broken the law if they weren't induced or tricked into doing something that by the law enforcement officers. So we see that defense raised quite a bit, particularly I would say in drug trafficking and sex acts related crimes, like child pornography. Not that it holds up in court, but it's one that's raised. Necessity. The defendant contends that they were acting to prevent imminent harm. I had to do it because the alternative was that something worse was going to happen, and that there was no legal alternative to the action that they took. Justifiable use of force would be where the defendant contends that the use of force was necessary to prevent imminent death or greater bodily harm to the defendant, or another one to prevent imminent commission of a force of a felony. So they were justified by their actions, kind of like the self-defense component. Post trial, if the jury returns a verdict of not guilty, the government can't appeal the acquittal. So that's different than civil court. Remember, both sides can appeal. If the jury returns a verdict of guilty, the defendant may appeal the verdict by claiming prejudicial error of the law at trial. Now, this is kind of a tricky area because so many people are relying on public defenders for these appeals. And so many of these appeals, once somebody goes to prison, are done pro se or done kind of, once they get to prison, they have a lot of time to think about what happened in a case. And so a lot of times that's where you you may see someone filing a appeal. You also see, other appeals that are filed when someone's found guilty and maybe not finding jail time. So if no appeal, then the defendant is sentenced after the judge receives additional information relevant to sentencing, right? So there are a lot of different factors that we take into consideration with sentencing. Is this the first time that they've been to prison? Had they had other behaviors before that would lead us to believe that they need to spend more time in prison? Should we go on the minimum side or the maximum side? So a variety of factors that go into play there. If you get a moment, take a pause and read through these questions and see if you can figure out the answers. Just kind of a checkpoint to see where you're at in understanding some of the material. All right, I'm going to wrap up this unit by talking about 3 kind of major acts. The Racketeer Influence and Corrupt Organizations Act, so RICO, which prohibits a person or persons employed by or associated with an enterprise from engaging in a pattern of racketeering activity. So anyone whose business or property has been damaged can sue to recover damages and attorney's fee in the civil action. So we see a lot of federal RICO raised in organized crime, so a lot of drug crime. Actually, I saw some RICO charges associated with Bitcoin in the last 5 or 7 years. And so that's another area. The False Claims Act was created to protect the federal government against financial loss due to fraud against them by individuals and businesses. So basically someone who violates the False Claims Act, they do so when they submit a false statement or record to the federal government. So for example, a federal contractor who submits hours worked for a time period which they didn't work usually results in damages, civil penalty, I think of $5,000 to $11,000 per claim that they make that's false. Sarbanes-Oxley Act. So in the wake of numerous well-known scandals, in order to curtail some of the ethical and criminal activities of managers and directors of corporations and address the accounting facets of a corporation, the Sarbanes-Oxley Act came alive. The Corporate and Criminal Accountability Act, which is another act, really deals with the deconstruction or misuse of corporate records. So again, dealing with some of the same fact scenarios that we saw with Enron, WorldCom, Global Crossing, and Arthur Andersen. And then the White Collar Crime Penalty Enhancement Act specifically addresses criminal penalties for ethical and illegal conduct. So Sarbanes-Oxley added a great deal of accountability and then just drove some additional acts for accountability to allow criminal actions for unethical moves that wouldn't otherwise meet some of these previous definitions of criminal behavior. And so you probably will see Sarbanes-Oxley if you are in a finance major or if you're in accounting, just because those acts are so central to the content that you cover. And that'll do it for criminal law. Have a great day.